Hello friends, in the series on income tax cases, today we will discuss a very unique case which came before the Kolkata ITAT bench, and the issue was that if the legal heirs do not get the probate of the will from the court, so whether in that case they will be obliged to file the return of income, or in other words, until and unless the legal heirs get the probate of will from the court, whether they will be obliged to file the return of income. This issue has been taken up by the tribunal in the case of estate of Kumar Chandra versus income tax officer, and this case is reported in 138 ITR Tribunal, short notes 11, and the date of the judgment is 15th April 2026. In the present case, the assessee was Binoy Kumar Chandra. He died on 13th June 2019. When the assessee died, his legal heirs applied to the Calcutta High Court for the probate of the will on 26th August 2021. But they get the probate in their favor only on 9th March 2022, and the order was received by them on 15th March 2022. But up to that time, the time limit for filing the return of income for the assessment year 2021 was already expired. The assessee was having some income in his 26 AS. So accordingly, the assessing officer issued the notice to the assessee under section 148A clause B, and accordingly the notice under section 148 was issued and order under section 148A clause D was also passed. The assessee was asked to file the return of income. The legal heirs filed the return of income on behalf of the assessee because now they were having the probate of will. They offered all the income which was appearing in 26 years and accordingly paid all the taxes. After that, the statutory notices under section 143 subsection 2, 142 subsection 1 were issued and the returned income of the assessee was accepted. But the assessing officer initiated and imposed the penalty on the legal heirs under section 270A on the pretext that if the notice under section 148A clause B would not have been issued, then they have not come to file the return of income. The pleading of the legal heir of the assessee was that they were entitled to file the return of income only when they get the probate in their favor. So they were not able to file the return in the due time, and the legal heir of the assessee also relied on the FAQ of the department, which says that the obligation to file the return arises only in case when the legal heirs get probate of will passed by the or ordered by the court. But the assessing officer imposed the penalty, which was confirmed by the CIT appeal on the ground that the legal heir of the assessee could not give the explanation to justify that why they have not filed the return of income on time. So when the matter was before the tribunal first of all said that in the present case it was not possible for the legal heirs to file the return of income until and unless there was a valid probate of will granted by the High Court. The tribunal said that in the present case section 270A subsection 6 is attracted and the assessee is fully able to demonstrate that there was reasonable cause for not filing the return of income on time, and the tribunal also relied on the FAQ of the department in which obligation to file return of income comes into play only when the legal heir get the probate of will in their favor. The tribunal also said that in the present case the most of the time for which the probate of will was in process was covered by the COVID period, and the Supreme Court has given the extension of the limitation period from 20th March 2020 to 28th February 2022 for all the periods. So considering that also in the present case the assessee is able to demonstrate that there was reasonable cause and there should not be any penalty under section 270A on the legal heirs. Friends, apart from this, my two respectful inputs are that there are a number of cases where the assessee filed the returns of income after the issue of notice under section 148 and suo motu discloses the income. So in that cases, the tribunals have taken very consistent view that the penalty should not be imposed, and in case of death, the tax can be collected from the legal years, but the penalty cannot be collected from the legal years. In this respect, there are numerous tribunal judgments which are in favor of the assessee. At the end of this video, once again I am repeating the name of the case. The name of the case is Estate of Binoy Kumar Chandra versus Income Tax Officer, and this case is reported in 138 ITR Tribunal, short notes 11, and the date of the judgment is 15th April 2026. Thank you, friends.